Okay. My name is Patricia Pagnani. I am the program director for the Toronto Bail Program, and I'm also the co-chair for the West Toronto HSJCC group. I'd like to start this session with a land acknowledgement. So reconciliation is about establishing and maintaining a mutually respectful relationship between Aboriginal and non-Aboriginal people in Canada. For that to happen, there must be awareness of the past. All of us must listen, self-reflect on how we are situated in that history, and work to understand and acknowledge the history from an Indigenous perspective. As a white settler, I want to acknowledge the land we are meeting on today is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabeg, the Chippewa, the Haudenosaunee, and the Wendat people, and is now home to many diverse First Nations, Inuit, and Métis. I also acknowledge that Toronto is covered by Treaty 13, signed with the Mississaugas of the Credit, and the Williams Treaties, signed with multiple Mississaugas and Chippewa bands. Toronto is the territory subject to the Dish with One Spoon Wampum Belt Covenant, an agreement to peaceably share and care for the Great Lakes region. Indigenous nations and people, Europeans, and all newcomers are invited to join in this treaty in the spirit of peace, friendship, and respect. So welcome, everyone. So this is the anti-racism series from the Human Services and Justice Coordinating Committee. The mandate of the HSJCC is to engage in cross-sectoral planning, coordination, and integration of services for individuals with complex human services needs like mental health issues, substance use, developmental and cognitive disabilities. There's 4 HSJCC groups. That's the Downtown Toronto, the North York, West Toronto, and Scarborough. And all of the locals report to the regional group for systems planning at a regional and a provincial level. If you're interested in joining the HSJCC, please indicate so in the chat box and with your email, and our coordinator, Domenica, will get back to you. Okay, so today's session will be recorded and uploaded to the HSJCC website and circulated to all of you who have registered and to all HSJCC members. So I would like to introduce our speaker. We are so very fortunate to have Jonathan Rudin with us. I heard him speak before, and he's just impressive. So Jonathan Rudin received his law degree and his Master's of Law from Osgoode Hall Law School in Toronto. In 1990, he was hired to establish the Aboriginal Legal Services and has been with ALS ever since. Currently, he is a Special Projects Director. While at ALS, he helped to develop the Community Council, the first urban Indigenous justice program in Canada, as well as the Gladue Court in Toronto. He has appeared before all levels of court and over 10 times at the Supreme Court of Canada, including R versus Ipeelee. Mr. Rudin has written and spoken widely on issues of Indigenous justice. His book, Indigenous People in the Criminal Justice System, won the Walter Owen Book Prize from the Canadian Foundation for Legal Research. He also teaches in the Masters of Law program at Osgoode Law School. And on top of that, on top of his many, many accolades, he also plays the mandolin and sings with Gordon's Acoustic Living Room, a group that plays regularly in Toronto and has a number of videos on YouTube. So everyone, it is my pleasure to present Jonathan Rudin.
Thanks very much, Patricia. Hi, everyone. So I'm very grateful for the invitation. What I want to do with today's talk is sort of build on the land acknowledgement and how Patricia started. But before I do that, I want a couple things about Aboriginal Legal Services. So Aboriginal Legal Services It's our English name. We were called Aboriginal Legal Services of Toronto when we started, but we changed our name because we have programs and services across the province. That's our English name. We also have an Anishinaabe name, and that name was given to us by Elder Jackie LaValle. We approached Jackie and followed the proper protocols, gave her tobacco, and asked her to give us an Anishinaabe name. And the name she gave us is Gakinagwai Wabama Deboywan, and that translates as all those who seek the truth. My understanding is when you're given a name, or a program's given a name, you then have to figure out what that name means, and different people will interpret the name differently. But for me, all those who seek the truth doesn't mean that we have the truth. It means that our job is to help people find the truth as it relates to them. And sometimes those people that we're helping are our clients, and sometimes it's decision makers, and sometimes it's people with authority and power. So that name helps guide us, and certainly helps guide me in the work that I do. So I want us to look at a question that's been concerning me over the last few years. It's taken up my time, both in terms of writing and speaking engagements, but also in litigation. And it builds on, in some respects, what Patricia said in her land acknowledgement. So the land acknowledgement acknowledges the existence of Indigenous people in these territories since time immemorial, and asks us to think about the historic relationship and the injustices that have occurred towards Indigenous people. But sometimes while we do this, we focus more exclusively on the past and we don't look enough at the present. And this is true generally of what we broadly call the considerations. And I've spoken to the HSJCC about Gladue before, so I don't want to spend a lot of time talking about the details of the case. But one of the things that people take away from the Gladue case, and then subsequently from Ipeelee and from decisions from the Ontario Court of Appeal, is that in order to deal with Indigenous people properly, we need to understand where they're coming from, what's their background, how did they come before the courts in the criminal context, and in a sentencing context, what sentencing options might make sense for the individual based on the historical realities of their family and their communities and their personal circumstances. And so the focus is often on the individual and their life and what's happened to them and the issues that we see that may be leading to the person becoming involved in the criminal justice system. When we engage in a Gladue analysis, we often look at history to the extent that if the individual was a residential school survivor, we think about the impacts of residential school and intergenerational trauma. We think of the 60s scoop. We think of all these things that may have had an influence on the individual as well from a historic point of view. What we don't do enough, and what the Supreme Court has asked us to do, is we don't look at the criminal justice system itself. Too often, people in the criminal justice system, and all of us on this call are involved in the criminal justice system in some way, or the criminal legal system, which is my preferred term, although I sometimes lapse back into justice, but the criminal legal system, we somehow exempt that system. And we act as though that system is not part of the problem. And that's just wrong. It's wrong, and the Supreme Court has told us it's wrong. The court system, the legal system as it exists currently, not leaving history aside, not forever, but leaving history aside, in its contemporary sense, the legal system is a source of discrimination towards Indigenous people. And that needs to be confronted by everyone working in the system. And that's where I want to have the focus of my discussion. It's why the title of this talk is, I can't remember what the title of the talk is, but something like, how do you fix a system when the system itself is the problem? So I'm not going to do a lot of referring to case law here, but I do want to start by going back to the Supreme Court. And I want to go back before the Gladue decision. The Gladue decision came out in 1999. But in 1998, the Supreme Court issued a decision in a case called Williams. And Williams was a case about an Indigenous man who was being tried for robbery. He had a jury trial, and he wanted to be able to question the jurors on the jury panel, potential jurors, about prejudice and bias towards Indigenous people. And his ability to do that was denied to him at the trial and at the BC Court of Appeal, but it was reinstated by the Supreme Court of Canada. And in Williams, the Supreme Court said, and this is in the very end of the decision at paragraph 58, the Supreme Court said, racism against Aboriginals includes stereotypes that relate to credibility, worthiness, and criminal propensity. And then they say at the end, there is evidence that this widespread racism has translated into systemic discrimination in the criminal justice system. And this is really significant because what the court is saying here quite clearly is that the criminal justice system itself is a source of systemic discrimination towards Indigenous people. And this is a finding that the court has reiterated on a number of occasions. So, for example, they talk about, and I'm going to come back to this, but they talk about systemic discrimination in bail, in the Gladue case, and in the Ipeelee case. In Ewart, which is a case about Indigenous people in prisons, the court said numerous government commissions and reports, as well as decisions of this court, have recognized that discrimination experienced by Indigenous persons, whether as a result of overtly racist attitudes or culturally appropriate practices, extends to all parts of the criminal justice system. And one of the things that's really significant about these findings by the Supreme Court is that the Supreme Court is often concerned with narrowing their decisions. They want their decisions to be very narrowed and tailored. But in these cases, in Williams, even though it was about juries and prejudice towards Indigenous people on juries, the court didn't restrict their finding to juries. They said the whole system. Racism permeates the entire system. And in Ewart, decided 20 years after Williams, the court said the same thing. Although Ewart was about prisons, the court didn't restrict their findings about racism and systemic discrimination towards Indigenous people to prisons. They once again reiterated that it extends to all parts of the criminal justice system. And then importantly as well, a year after Ewart, the Supreme Court decided the case of Barton. And Barton, as you may recall, was involved with Mr. Bradley Barton, and Bradley Barton killed an Indigenous woman named Cindy Gladue. And one of the issues in the case was the fact that during the trial, everyone involved, the judge, defense counsel, and Crown counsel, referred to Ms. Gladue over and over again as an Indigenous person, as a sex worker, etc. And this was a concern for a number of people involved who got involved in the case, including Aboriginal Legal Services. And the court said in that case in Barton, paragraph 199, the court said trials do not take place in a historical, cultural, or social vacuum. Indigenous persons have suffered a long history of colonialism, the effects of which continue to be felt. This court has acknowledged on several occasions the detrimental effects of widespread racism against Indigenous people within our criminal justice system. With this in mind, our criminal justice system and all participants within it should take reasonable steps to address systemic biases, prejudices, and stereotypes against Indigenous people. Indigenous persons, actually is what they said. So we see this over and over again. The Supreme Court makes this point over and over again. And those of us involved in the criminal legal system often acknowledge this fact, but we have some difficulty in translating that into what we actually do. When we actually have an Indigenous person before us, how do we address the systemic discrimination within the system? And so let me talk a bit about systemic discrimination. I'm sure it's a term that most of you are familiar with, but I want to talk about systemic discrimination. Systemic discrimination is contrasted to a term that's often used as formal discrimination. Formal discrimination means, or formal discrimination is you're discriminating against someone expressly in the language of the statute or the laws that you're enforcing. But systemic discrimination speaks to discrimination that is baked into the system, that it doesn't come out. You don't look at the system and you wouldn't say, oh, that system's discriminatory. You'd say that system treats everybody the same. But yet it has an unequal impact on people, a disproportionate impact on some people. And that is in and of itself a problem, as the Ontario Court of Appeal recognized in a case called Leonard from 2012. I'm not going to read from it, but this idea of formal equality versus what's called substantive equality, or formal discrimination versus substantive discrimination, is a very important concept to understand. And so let me give you a couple examples of systemic or substantive discrimination. So one example that, as I mentioned, that the courts talk a lot about is bail. Now, when you look at our bail legislation, there is nothing in it that says that Indigenous people or members of other vulnerable groups are to be treated differently. Our bail system treats everybody the same. But what does that mean when we say it treats everybody the same? Well, those of you who are involved in the bail system, and Patricia in the bail program will know this all too well. When someone goes for bail, the onus is on the Crown to show that the person is on a balance of probability is not likely to show up, or is going to be a danger to the public. And how do we arrive at that? How do we determine if someone's likely to attend in court, if someone's a risk not to attend? Well, we look at things like, does the person have a job? Does the person have a home? Does the person have a prior criminal record, particularly a prior criminal record for failing to appear in court or failing to comply with the bail decisions? Because we think objectively, if you have a job, you're not likely to run away. If you have a home, you're not likely to run away. If you've never been in trouble with the law, there's no reason to think you won't respect the law. So those are, we would say, objective criteria. The problem with them, as the Supreme Court expressly noted in Ipeelee and expressly noted in Gladue, is that puts Indigenous people at a disadvantage, because we know that Indigenous people are overrepresented among the homeless. We know Indigenous people are overrepresented among those with administration of justice offenses for a whole bunch of reasons, some of which I will try and get into. And we also know, and this is really important, now it gets back to the history part, we also know that the reason Indigenous people are overrepresented among the homeless, the reason Indigenous people don't have the same level of employment as non-Indigenous people, is not because Indigenous people don't want a home, don't want to work. It's because of largely the impacts of colonialism. The way the Canadian state was set up, the way the Canadian state set about to try to destroy Indigenous people as a people. They failed, but they caused great deals of harm. The state caused that harm. And now the consequences of that harm are being felt by individuals coming before the court. And if we don't look at systemic discrimination, if we don't look at how these things arise, then we're liable to say, well, we'd like to give you bail, but we can't because our objective criteria don't allow us to do this, which basically means the system has impacted you and your family and your communities in a way that we recognize isn't your fault, but nevertheless, we're not going to grant you bail because we're going to make assumptions about you based on the fact that you don't have a house, you don't have a job, even though those assumptions may not be valid, because the reasons you don't have those things actually don't necessarily speak to your personal characteristics. So that's sort of one of the ideas of systemic discrimination and why the criminal code was recently amended so that in the bail context, judges are required to specifically look at the circumstances of Indigenous accused persons and also members of other vulnerable minorities when it comes time to consider bail. Because there's a recognition that the systemic discrimination in the system leads to the disproportionate overrepresentation of Indigenous people and other vulnerable groups in remand custody. And I'm going to talk about some of the impacts of remand custody shortly. So another example of systemic discrimination that we often see are risk assessment tools. Many organizations use risk assessment tools when working with clients. Probation and parole uses risk assessment tools a lot. Different probation and parole programs across the country use risk assessment tools differently. But risk assessment tools are another example of systemic discrimination, or they can be an example of systemic discrimination. So risk assessment tools, as you may know, usually have two aspects to them. They have what are called static factors and dynamic factors. Static factors or dynamic factors, let me start with those. Dynamic factors are those factors that are specific to the individual, that have arisen because of choices and things that the individual has done. Static factors are factors that the individual has no control over, but have an impact on their life. So for example, is your family, do you have a mother and father? Are you living with your mother and father? Were you ever adopted? Do you have relatives who have a criminal record? These sorts of things are called static factors. They're seen to be criminogenic. If you have too many of these, that might make you a risk of becoming involved or continuing to become involved in the criminal justice system. And so we use risk assessment tools to make decisions about whether someone should get bail. Sometimes we make decisions about whether someone can be released in the community when they're being sentenced. Risk assessment tools are used when people are brought into custody to determine their level of classification, certainly at the federal system. So we use these tools. Again, the tools are objective. That's what we're told. They're objective. They don't set out to discriminate against any particular individual or any particular group. But we know that the realities of the impacts of colonialism on Indigenous people means that Indigenous people face much more family breakdown. Indigenous people are much more likely to be involved in the child welfare system. The mass incarceration of Indigenous people in Canada are 9 times more likely than non-Indigenous people to be in jail at any one time. In Ontario, the figures are 6 times more likely. So an Indigenous person in Ontario is 6 times more likely than a non-Indigenous person to find themselves in jail. And just sort of as an aside on that point, Statistics Canada, which calculates these figures, has pointed out that the 6 times actually underestimates it if you're comparing Indigenous people to, for example, white Ontarians, because we know that certainly Black Canadians, Black Ontarians also are overrepresented in the system. And so their overrepresentation reduces the rate, the impact and the significance of the comparison of Indigenous to non-Indigenous people involved in the justice system. But Indigenous people are 6 times more likely to be involved in the justice system or to be actually in jail. So what that means is if you're an Indigenous person, without doing anything, the static factors in your life are going to mean that you are more likely to have a relative who has a criminal record, and you're more likely to associate with people with criminal records. So what does that mean? It means that at Aboriginal Legal Services, most of our staff are at high risk to reoffend, even though many of them have never offended at all, because of the impact of static factors in risk assessment forms. And there have been cases where judges have pointed out that the risk assessment tools are clearly, there's something wrong with risk assessment tools because they are finding someone who, for example, is offended criminally for the first time at 25 or 26 at a high risk to reoffend when they have never offended before. And so that's another example of systemic discrimination. It's baked into the system. And we recognize this on one level. We recognize this on one level, but the question is, how do we factor that into the decisions that we make on a daily basis with the clients that we work with, the individuals that we work with? So I want to focus in on another, I'm going to spend most of my time talking about a related issue, which is another systemic issue that we as a criminal system have now started to recognize. But while we recognize it, on the one hand, we have a hard time doing anything about it on a day-to-day basis, and that is wrongful convictions. And more specifically, well, wrongful convictions. So we all know about wrongful convictions. Wrongful convictions are sort of the worst possible thing that can occur in the justice system, the legal system. We think about Donald Marshall, we think about David Milgaard, we think about Jean-Paul Morin. Paul Morin. I probably screwed up his first name. Sorry about that. These are all people who were wrongfully convicted. Now, there are many more. There is a directory of the wrongfully convicted. There's a very good website if you want to look at wrongful convictions in Canada. You'll discover that Indigenous people are overrepresented among those who are wrongfully convicted in Canada. But our notion of wrongful convictions tends to make us think that wrongful convictions are these things that happen. They're awful, but they don't happen all the time. We're used to seeing every so often a news article where an organization like Innocence Canada has helped exonerate someone who was mistakenly convicted. But wrongful convictions occur every day. Every day. In Toronto, multiple times a day, there are wrongful convictions happening. And they're happening not after trial. They are the result of what are referred to as wrongful conviction guilty pleas. And the Canadian heads of prosecution, which is the attorneys general and ministers of justice from provinces and the federal government, have now recognized that wrongful conviction guilty pleas are a reality. They've issued discussion papers on this. And we know that it happens. Now, why do wrongful conviction guilty pleas happen? Well, there are a couple reasons that they occur. One reason they occur goes back to bail. If someone is charged with a criminal offense, it's a relatively minor criminal offense, not a really serious one, and they're denied bail, they are often then offered a deal by the Crown for a sentence of time served or, another 20, 30, 40, 50 days or whatever. Now, that becomes a very attractive offer when you think about how long it takes to get a trial in Toronto. It takes months and months to get a trial in Toronto. Even if you're in custody, it can take months and months to get a trial. So whether you're guilty or not, if you're denied bail and you're charged with a criminal offense and the Crown is offering you, a 60-day sentence or something like that, you're going to want to take it, even if you didn't commit the crime, because it's the only rational thing to do. It's the only rational thing to do, because why would you want to spend time in custody awaiting a trial, which even if you're successful, you still will have spent more time in custody than you would if you pled guilty. So many people plead guilty to criminal offenses because it is a rational decision, not because they did it, not because they want to be upfront and take responsibility for their offenses, because they don't really have a choice. It doesn't make sense for them to plead not guilty. The decision on bail is the decision that leads to everything else. And so that's one reason that we see wrongful conviction guilty pleas. It's a problem. Lawyers will tell you, this is a real problem. You go see your client and your client says, I'm innocent, I didn't do it. And then they're denied bail and they say, okay, I'm going to plead. Lawyer says, but you said you were innocent. Yeah, well, yeah, I lied. I wasn't. Or maybe they'll be even more frank with the lawyer and say, yeah, I know I said I was innocent, but I don't want to spend, another 4 or 5 months in jail. The Crown is offering me a good deal. I'm going to take the deal. And even if the deal isn't objectively the best deal in the world, it's better than spending time doing dead time in an overcrowded facility, no access to programming. So that's one of the reasons that we see wrongful conviction guilty pleas. And if we get back to bail, one of the reasons that we see people denied bail is because, for example, they have a history of failing to appear or failing to comply with bail conditions or with probation conditions. And Crown attorneys, when they're having a bail hearing and they see someone and the person's in that situation, they'll say, well, your honor or your worship, depending what level of court they're at, we can't let this person out because they say they're going to follow the directions of the court, but look at their track record. They have this history of fail to appear and fail to comply. That clearly shows that they have no respect for the courts or the orders of this court. And so what you see in that process is a lawyer, the Crown in this case, making conclusions about a person that they know probably nothing about. They don't know this person. They can't say, I know this person's told me they don't care about obeying laws of the court. They don't know anything about this person. They're basing this on the fact that there are prior convictions. And this is what we do so much in the criminal justice system. It's one of the challenges with the criminal justice system, the criminal legal system, is that we fill in the gaps. We know very little about the individuals that come before the court for bail or for sentencing. And we fill in the gaps with whatever information we have available to us. And we act as though that information has something useful. as useful information. It allows us to draw conclusions about the individual. And so a judge or a justice of the peace who's deciding on a bail application for an individual will have the person's prior criminal record. And they'll be urged, often by the Crown, yes, look at the prior criminal record. Because they have these fail to appears and fails to complies, that means that they're not likely to show up to court. And therefore, they're not amenable to your decisions. They say they're going to listen to you, but they're not going to. We know that because we can see based on their prior record. This is a phenomenon that Daniel Kahneman, I like talking about this. Daniel Kahneman wrote a book called Thinking Slow and Fast. He won the Nobel Prize for Economics, although he's not an economist. And Thinking Slow and Fast is a really interesting book. And he talks about a phenomenon called what you see is all there is. And what that phenomenon means is we make decisions often with imperfect information because we can't get enough information in the time that we have available to us. And so we base our decisions on whatever information we have. And we assume that the information that we have has some validity. And so in the bail context, we rely on prior convictions for administration of justice offenses as though it has some meaning, as though it tells us something about the individual. We don't know that it does. We don't really have evidence that it does, but we work on that assumption. We work on the assumption that this is telling us something about the person. The problem is it doesn't. It often doesn't tell us stuff about the person. And I've seen this, there are a number of ways that this is played out. An example of the way systemic discrimination works in the criminal justice system. Many years ago, when we started the first Gladue court, which started at Old City Hall back in 2001, after the first few months, I remember talking to Crowns and Defense Counsel, and they were struck by the difference in criminal records between Indigenous and non-Indigenous people. As you may know, at a bail hearing, when the judge is handed up someone's criminal record, or at sentencing, when the judge is handed up a criminal record, what you get are the above the line, what are called the above the line offenses. Those are the offenses that the person has pled guilty to or been found guilty of. There is a whole below the line of charges that were laid against the person, but were withdrawn for whatever reason. And what was pointed out by Crown's and Defense Counsel who were sitting in Gladue court back, when the court started, was that Indigenous people had a lot more stuff above the line. That when what it looked like is when an Indigenous person pled, they were pleading to more charges than a non-Indigenous person would plead to. I mean, we have some phenomena, systemic issues in our criminal justice, in our criminal legal system. One of them is overcharging. People are routinely charged with more offenses than they really should be, but they're charged with them in order, sort of on the assumption that over the course of the way the case works its way through the court, some of these charges will disappear. So for example, if someone is on probation and they commit a criminal offense, they may be charged with fail to comply with probation ×2 or ×3, 3 separate charges because they didn't keep the peace and be of good behavior. They weren't in their home if they had a timing restriction, a curfew, various things. So they'll have 2 or 3 things. And often when the person finally resolves their matters and pleads to them, a lot of those or all of those fail to appears or fail to complies get taken away. But for Indigenous people, that's not what happens. That's not what happens. So Indigenous people end up with worse looking criminal records than non-Indigenous people. They present poorly when it comes to a bail hearing. It makes it more likely that they're going to be denied bail. Indigenous people who live in First Nations communities, even in Southern Ontario, that are near court locations, often face huge challenges getting to court. We have an office in Sarnia, and the Sarnia court includes the Walpole Island First Nation. Now, Walpole Island, for the last number of years, has had their own court, which has been great. But prior to that, in order to get to court in Sarnia, if you lived on Walpole Island, you had to drive 50, 60 kilometers to Sarnia. And a lot of people in Walpole didn't have cars, and there wasn't public transit. And it was really difficult to get to court. And if you have to go to court 6 or 7 times before your matter is resolved, which is not unusual, the fact that someone may miss one court date is not a surprise. But then the person may get a fail to appear conviction. And if when they finally resolve all their charges, that's not removed, it's going to look like they just decided they didn't want to come to court. Same thing applies to Indigenous people, members of who live on Six Nations. People who live on Six Nations don't live far from Brantford, but it is not easy to get to Brantford. And so people will end up with fail to appear convictions or fail to appear charges, which may, again, systemically, because defense counsel may not be as zealous and Crowns may be more willing to push to leave these convictions on their record. So what does that mean? It means that if your record has a bunch of fail to appears and fail to complies on it, it's going to be harder for you to get bail the next time. And the next time you come up, then you're going to plead guilty. And this is this circle that goes on. This leads to, one of the things that leads to wrongful conviction guilty pleas is not because necessarily the person's guilty, but because the way the system works, it leads to these sorts of pleas. On top of that, for Indigenous people, there is a belief, and a very rational belief, that the system doesn't work for them. So Frank Iacobucci, who was a Supreme Court judge and co-wrote the decision in Gladue, in 2013, wrote a report for the provincial government called First Nations Representations on Ontario Juries. So he was looking at a question about why Indigenous people were underrepresented on juries in Ontario. First Nations people specifically, overrepresented, mass incarcerated, but underrepresented in juries. And one of his findings was that when charged, Indigenous people tended to plead guilty to resolve their charges because, quote, they believe they will not receive a fair trial owing to racist attitudes prevalent in the justice system. And that was Justice Iacobucci's finding. And this finding was adopted by the Ontario Court of Appeal in 2 cases, a case called CK and a case called King. And what those cases talk about is the fact that we have to be careful about assumptions we make about Indigenous people based on their prior criminal record, because it may not tell us what we think it's telling us. When Indigenous people say, I'm pleading guilty because I'm not going to get a fair shake, that's not because they don't understand how the system works. It's often because they understand all too well how the system works. In the Iacobucci jury representation report, one of the First Nations organizations described the criminal justice system as a conveyor belt for guilty pleas as it relates to Indigenous people. And I reflect back, it's a long time ago, back to the late 80s, but I'm old, so I can do that. When Aboriginal Legal Services was being set up, we did I didn't, but there was a needs assessment done. And a judge, judges were interviewed in Toronto about Indigenous people before the courts. And one of the judges said that Indigenous people in some ways were sort of the quote unquote best, I'm not quoting him directly, but the sort of the best people in the system because they so quickly took responsibility, pled guilty, and just were sentenced. They didn't assert their rights. They didn't fight. They didn't have bail hearings. They just pled guilty and went along with what happened. And this is because this is the experience that Indigenous people have had of the criminal legal system. And so what you have is you have this phenomenon of wrongful conviction guilty pleas, specifically as it relates to Indigenous people. And this is, again, this is not, I mean, this is me telling you this, but in addition to me telling you this, Justice Yakabuchi talked about it. The provincial and federal heads of prosecution have talked about it. The Ontario Court of Appeal has talked about it in a couple cases. So we know that this exists. We're not pretending that this is just something that maybe happens. No, it happens. It happens all the time. It happens all the time. But what does this mean to you in your work? So let me, before I get to you, let me talk about how I posed this in another context. I had the opportunity a couple years ago to talk to members of the Parole Board of Canada. And the Parole Board of Canada is the organization, of course, that determines whether someone's going to get parole or not. And because Indigenous people are so overrepresented in the federal correction system, over a third of those people in federal corrections are Indigenous, and almost half of the women are Indigenous, if not more than half the women are Indigenous. They get a lot of Indigenous people come before the parole board. And I asked the parole board, so what happens if you're looking at someone's prior criminal record and they tell you they didn't do it? They pled guilty, but they didn't do it. What do you do about that? Particularly given what you know, what you should know. Well, I went over all this information with them. What you know about wrongful conviction guilty pleas. What do you do about the fact that if an Indigenous person says, yeah, I know it's on my record, but I just pled guilty because I just wanted to get it over with, or because the Crown gave me a good deal and I didn't get bail. What do you do with that information? And they really don't have a way of dealing with it. At least they didn't when I met with them. I don't know if I'm not so self-important to think that my meeting with them made a huge difference in their lives. But what do you do with that information? What do you do with the fact that we know that wrongful conviction guilty pleas happen? We know that they happen disproportionately to Indigenous people. What do we do with that? And it's not to say that the person didn't plead guilty. They did plead guilty. But the question is, what weight do we put on that conviction? What assumptions do we make about the person? And this is where the systemic discrimination comes into play. And I think where organizations need to look very carefully at how they work with Indigenous people. And I'll just focus specifically on Indigenous people. This applies probably to other groups as well, but I don't know enough about other groups to speak about that. What do you do about that? If someone says to you, if you're meeting with someone and they say, yeah, I know, but I didn't really do it. Do you think, okay, well, this is a problem because you're not prepared to own up, to take responsibility for what it is that you did. This is a problem. You're not ready to go into certain programming or whatever. What assumptions are we making about the person based on the conviction? We're not arguing that there was, I said, not arguing there was a conviction, but what weight gets put on it? Because clearly, if people are pleading guilty to things they didn't do, if that happens every day in court, and it does happen every day in court, and it happens disproportionately to Indigenous people. What does that mean for us in our day-to-day work? There's a bail case a number of years ago where Justice Schreck of the Ontario Superior Court was doing a bail hearing, and the individual had a lot of prior failed to complies and prior offenses. And Justice Schreck made, I think, the point that I think is really important, which is, he said, you know, I can't assume that the person didn't do these offenses, but I can't assume they did do these offenses. The guilty plea itself doesn't prove anything, because we know about the systemic discrimination that Indigenous people face in the legal system. And so he said, I have to be conscious of the weight that I'm placing on this. And this is the issue. The issue is that we pretend that these things like prior convictions tell us something inherent and innate about the person. We believe that, or we act like we believe that, even though we know that it doesn't do that in many cases. And that's a real challenge, because now we've recognized the systemic problem. The systemic problem is wrongful conviction guilty pleas, the distrust Indigenous people have with the justice system. That's a systemic problem, and we acknowledge it. But how do we acknowledge it in the work that we do on a day-to-day basis? That's the challenge. And it's not an easy challenge, but I think it comes, in many ways, comes to weight, comes to what assumptions do we make about the person? King, which is a decision from the Ontario Court of Appeal that I mentioned earlier. King is a very interesting decision where judges are trying to deal with this. And so let me tell you what the court sort of said in King. This may help. So this won't come up to you. This is a trial issue. But in Canada, the Crown is not allowed to introduce in front of a judge or the jury, more particularly the jury, but also the judge, a person's prior criminal record. You can't introduce someone's prior criminal record until the sentencing stage. You can't introduce it during the trial, because it could lead to people thinking, well, because this person has committed offenses in the past, they're more likely to commit offenses in the future. It's called propensity reasoning. So you're not allowed to do that. But there is one exception. There's one exception. And that exception is if the individual chooses to testify. So if the individual testifies in their own defense, then the Crown can bring the person's criminal record to and cross-examine the person about their criminal record. Now, they can't cross-examine them on, well, you committed a robbery before, therefore you've committed it again, but rather they can cross-examine the person about their prior fail to appears and fail to complies and other things that would impact their credibility. In other words, the Crown can say, look, you've been convicted 5 or 6 times for failing to show up to court, for not complying with your probation. You don't care what judges tell you, do you? You don't care what the court tells you. You don't care to listen to your probation officer. Why should we believe you when you've told judges over and over again you would do these things when it comes to bail, or you do these things when it comes to probation, and you didn't do them? So it's allowed to be used, your prior criminal record, to challenge someone's credibility. And so in King, the question was, it was about an Indigenous man who was charged with murder, and he had, his defense was a self-defense defense, which means he had to testify. He had to talk about why he felt that he had to do what he did. And this meant that the Crown was going to introduce his prior criminal record. And so there's a provision in the in the law for something called the Corbett application, which is an application that defense counsel brings and says, normally you could ask this person questions about their prior criminal record, but in this case, I don't think they should be able to ask questions about, these particular offenses. And the question in King, without going into massive detail, was how the Gladue factors and understanding systemic discrimination, whether that has an impact on a Corbett application. Does a judge need to think about the fact that the individual is Indigenous when you're looking at systemic discrimination that juries have towards Indigenous people, and the fact that the conclusions that you draw from someone's prior criminal record about their credibility may not make any sense if these are wrongful conviction guilty pleas. And the court, in the end, agreed that a Corbett application, a judge hearing a Corbett application, needs to be particularly sensitive when it's an Indigenous person who's testifying, because their prior criminal record may suggest that juries or judges, if the judges are sitting alone, draw certain assumptions about the person based on their record, but those assumptions are not necessarily valid based on what we know about how the system actually operates. And so that's what I want to leave you with. We're going to get to questions shortly. So I've got a bit of time for questions. If not, I'm going to fill it in by continuing to talk. But this is the issue I think we need to think about. It's not enough to say, I know that the system discriminates against Indigenous people. And I know that wrongful conviction guilty pleas exist. But too often what we do is we say, that's over there, but now I've got my client in front of me, and I'm not going to let any of that impact the way I work with the client. If the client denies that they did, if it's a probation and they denied that they committed the offense that they committed, or they deny that they committed some of their other offenses, well, I'm going to assume, because I have to for some reason, I'm going to assume that they're lying, that this is just them not being willing to accept responsibility for what they've done. And I would suggest that's not an assumption that you can safely make. Now, maybe you know the person, maybe you have a history with the person, that may make a difference. But that's not an assumption you can safely make, because we know about wrongful conviction guilty pleas. There are all sorts of there are other systemic issues about wrongful confessions. There are all sorts of other issues that I didn't have time to get into. But this is, I think, the challenge. And I urge you to try and take that to your work, to take that to your work personally, and to take that to your work institutionally. To ask yourself, how do we factor these issues in to the work that we do? How do we factor this in to the clients that we work with? What are the assumptions that we're making? What value are we putting on things like prior criminal records, which maybe just shouldn't have that value, that can't really bear the weight that we give them? Because I think that's one of the things that comes very clear from the Iacobucci report, from CK, from King. Criminal records don't tell us what we think they tell us. We have believed mistakenly that they're giving us some window into the person's background and life, and they do not necessarily do that. They may, but they may not. And not knowing anything more than that, I would suggest it's wrong to assume that a prior criminal record is going to tell you anything useful about the person, because maybe it tells you nothing. And I particularly, obviously, as it relates to these sorts of offenses where people are pleading guilty relatively quickly. If someone's had a trial, I think, I'm not saying that's perfect, but that gives you stronger reason to believe that perhaps the conviction makes sense. But over 90% of cases in Ontario resolve themselves by way of guilty pleas. Trials are the exception. Most of the time you have an individual who agrees to plead guilty, and the judge reads out, tells here's what happened, tells the person, do you agree? And the person says, yes, I agree, because that's the way the game's played. But we know that people are saying that and not meaning it, and we know that people are pleading guilty to things they didn't do. So let me pause here. And Patricia, any questions?
Yes, actually. Thank you, Jonathan. There's a question here from Ed, and he'd like to know, do you know approximately how many people have been acquitted due to the systemic discrimination in the legal system?
So, I mean, this is the challenge is that the way systemic discrimination works, it's hard to be acquitted because of that. What systemic discrimination does is lead to prior convictions. So it's more to what extent, and I think we're seeing this, for example, what we're seeing more of now is in bail hearings, judges putting less weight on criminal records and people getting bail when they would not otherwise have got bail before. So I think that's where we see it more particularly, is at the early stage, at the bail stage. It's where I hope that we're seeing it. Because as I said, for most people, the single most important decision that's made in their criminal case is not whether they're guilty or innocent. It's whether they get bail. Because if they don't get bail, we know where the trajectory goes.
And Lori has noted that you seem to prefer the words legal system rather than justice system. Can you speak a bit about that?
That's a good question. Thank you. I guess because the word justice has with it an objective determination. Justice is this thing that we strive for. It has an element of fairness, that the system works and people are heard, and that's just not the way this system works. It for most Indigenous people, for many Indigenous people, they don't get a lot of justice out of the system. And there have been 13 or 14 inquiries into Indigenous people and the criminal, often they're called the criminal justice system. Look, my book is called Criminal Justice System. I'm trying to get out of the habit, but people get used to it. But justice has an objective quality to it. And I don't think the system really lives up to it. Legal describes a system of rules. And we know that the legal system is a system of rules. That I can accept. But justice has a normative aspect to it that I just don't think, at least in relation to Indigenous people, the system, it's not a term the system deserves yet.
I have a question, Jonathan.
Please.
So I know that you helped to develop the very first Gladue court in Toronto. And I can tell you from working in the system for 35 years and being in a lot of the specialty courts in the Toronto region and the Central East region, that the Gladue court at OCJT is one of the finest. I really say that confidently because it's so welcoming. Can you talk a bit about how that court helps to address the issues of systemic discrimination?
Thank you, Patricia. That's a great question. All the questions are great. I was afraid of saying that's a great question. And someone asks a question, don't say it's a great question. They don't like my question. No. So the Gladue courts have evolved over time. When we started, it was, hey, let's have a court. But the court looked like any other court. It operated a bit differently, would look like every other court. But now the court really functions differently. And when the Gladue court was being designed at the Ontario Court of Justice, Toronto, a number of things were done right off the bat to make a difference. So for example, the court sits in a circle. That's its default position. Everyone sits around in a circle. And the judge doesn't sit on the dais. Sometimes the judge wears robes, sometimes the judge doesn't wear robes. But everyone sits around the circle so people can look at each other. And it's really interesting when people sit around in a circle, the way in which people relate to each other and talk to each other is different. You know, when you're the defense counsel or Crown and you're talking to the judge, the accused person is, you don't even see that person because you're focusing everything up there. And so people can often say things that they would not say to someone's face. When you sit in a circle, people tend to moderate their language on every side. People start to see each other as people. One of the things in the Gladue court, when you go into the Gladue court, there's a screen that's down and you don't see the coat of arms, you don't see the Canadian flag. Again, that's not something that most of us think, oh yeah, well, what's wrong with that? Well, that can be very significant for a lot of Indigenous people. That flag and that coat of arms doesn't have the same meaning. One of the things that the judges have started to do is they allow food in the court. So people who are out of custody can get a granola bar, get something to eat, because we know that people function better when they've have food. And people who have food insecurity, who are living on the streets, it's hard enough to get to court. But if there's food, not only is an incentive to go to court, maybe, but you know, it also allows you to think more rationally and talk to people. So there are all sorts of ways that courts can be redesigned. And part of the idea of, again, the systemic discrimination is just always assuming that courts have to look a certain way. Why do they have to look that way? There's nothing that says in the criminal code that a court has to look a particular way. We just always assume that. And it's making those assumptions that is problematic. And the way the Gladue court operates in Toronto shows that if you challenge those assumptions, you can make real change, and it makes real difference.
Yeah. And I think that it's so helpful to have designated staff that are very well versed in Indigenous history and Gladue principles.
Yeah, I think that's another really important point that we've had to discuss often with people, which is, you know, at the Gladue court, and this is true, I mean, I can't speak to all the Gladue or Indigenous persons courts in Ontario or across the country, but in many of those courts, there are particular people who sit, particular judges, particular crowns, particular duty counsel. And people will say, and people have often said, well, look, Gladue is the law. Everyone knows the law. Everyone should be able to sit in a Gladue court because everyone should know the law. And it's true, everyone should know the law. But how the law is applied and how it needs to be applied, some people are better at it than others, and some people have an interest in working with Indigenous people and are willing to accept that there is systemic discrimination in the system. And so it really matters that there are people who with specialized knowledge and interest. It doesn't guarantee, you know, it's important to understand that that doesn't guarantee outcomes. It doesn't guarantee that someone will get bail, doesn't guarantee that someone will get a more lenient sentence or won't get a jail sentence. But it means that the more likely the person will be heard and felt that they're heard. I mean, this is so crucial because if you go back to the Yakabuchi report, Indigenous people just feel that the system has nothing to do with them. And being able to go to a court where people take the time to learn how to pronounce your name properly, want to know about you, you know, when someone's given the opportunity to speak, that they're actually given that opportunity to speak. You know, many people have been in court where before someone's sentenced, the judge has to say, do you have anything you want to say? But the minute the person starts to speak, everyone starts looking away and defense counsel's trying to tell the person to be quiet. Like, being in a place where people actually really want to take the time and listen to you, that it's huge. And frankly, not everyone's comfortable with that, and that's okay. But if you're not comfortable with it, then you shouldn't be sitting in Gladue court.
There's a good question here, given all the talk about bail reform. There's pressure in Ontario to be more restrictive in allowing bail. How will this impact your concerns?
Yeah, that is a good question. So I find this discussion about bail very problematic. There is no evidence that the bail reform that was brought about a couple years ago has actually led to fewer people being released. We still have, in Ontario, we still have more people in custody who are factually innocent than who are in jail because they've been convicted of a crime. More than 50%, I mean, we're 60, I can't remember if it's 60 or 70% or more, are in jail because they've been denied bail and they're awaiting trial. So people keep talking about the fact that people keep getting let out on bail, but there is actually no statistics that show that. And so this is a problem, and I'm very, very concerned about these attempts to make it harder for people to get bail. It's already difficult. I mean, despite what people think, it's already really difficult to get bail. And if we make it harder and harder, the systemic problems in the system are going to get worse. I just find it very troubling that people are prepared to assert without any basis in fact, any statistics, that bail is somehow easy. That just isn't the case. But yes, I very much worry about what's going to happen. But I'm hoping that, and we will have to see what the amendments say, because judges and justices of the peace obviously are bound by the criminal code.
Is ALS the only agency in Ontario that's funded to write Gladue reports?
No, there are a number of organizations in the province that provide Gladue reports in the north. So we do Gladue reports in Southern Ontario and what we refer to as the near north. So I know in Toronto we think of Sudbury and North Bay as the north, but in Thunder Bay they think of Sudbury as Toronto. So we do them in not exclusively, but a lot of Southern Ontario. In London, Ontario, the Namarine Friendship Centre does Gladue reports. First Nations Technical Institute does Gladue reports in for Tyendinaga and for Belleville, and sometimes in Kingston. There are different Gladue report services across the province. So if someone wants to know, if you go to our website and we list the court locations we do Gladue reports for. If you're not sure who does Gladue reports in other regions, you can always send us an email and we can tell you. But pretty much, not all, but almost all the province now is covered by Gladue reports written by Indigenous organizations.
And there's also a question about support after they're released. Do you believe that there's a lot of supports in place for the Indigenous population?
I think there needs to be more. We provide some support. We do have some aftercare or after release help for people. Obviously, the biggest concern for people often is housing, and certainly what we've identified as an issue, again, a systemic issue, is a lot of the justice beds that have been created over the years have been created for people who have not been convicted of what are seen to be violent offenses. And a lot of our clients don't have access to those resources. There are issues that arise with service providers, shelters that require people to be sober and not consume alcohol. These push people into risky situations. So there's not as much support, but there is support, and we certainly try and provide as much as we can. But I also think I will say, I think it's important. Sometimes people get released on a lot of conditions. And when they get released, everyone in the room is kind of looking around going, I'm glad they got released, but I don't know how likely that's going to be. And I think one of the things that we need to try and do if we have clients who breach a bail condition or whatever, when we go back to court, we need to let people know about all the good things that the person's done, all the positive steps they've made. Too often, and this is a problem with the court, too often in the courts, the court really only sees failure. You get someone bail and they do well on bail and the Crown decides to divert or drop the charges, the court never sees the person again. So we only see failure. So it's important to try and construct successes for clients, because often clients will have done very well for, let's say, 3 or 4 or 5 months, and then they've breached a condition, but maybe there's a reason for that. So we shouldn't just assume that because something's happened that they shouldn't get bail again.
Okay. And there's also a question about the really long wait times for trials. Do you know if there's anything being proposed at this point to shorten the wait for trial?
Well, what we have for the wait for trial is the Jordan rule, and that's what we have. You have to have, I think it's 18 months if you're a provincial court, OCJ case. There are judges who are supposed to be appointed, crowns who are supposed to be appointed. It's not clear. I mean, there are some things in a broader level that can be done. Ontario is not a charge approval jurisdiction. One of the things that we found in British Columbia, for example, the police don't lay charges in British Columbia. In British Columbia, the crowns lay charges. The police gather the information, give it to the crowns decide if charges will be laid. In those jurisdictions, what are called charge approval jurisdictions, fewer charges go forward. What often happens in Ontario is the police are told an offense happens, they maybe investigate, not always that thoroughly, and then the person's charged, and the Crown's not really going to look at the matter until maybe it comes up for trial. And so that's one of the reasons that we have the backlogs. But I'm not aware of any particular innovations that are going to solve what is a really important issue anytime soon.
Okay. Very good. Now, I do see that there is a Teresa in the chat, and she said that she has a question that's very difficult to put in writing. Do you mind taking a verbal question, Jonathan?
I mean, I can't stay too long, but if it's quick, I'm okay.
Okay. All right. Yeah, because it's 2:17, so it looks like we have time for one more. So, Teresa, do you want to unmute yourself and ask the question? Okay. Don't know if she's still with us. Okay. I think she's gone. Okay. So I guess that is that's it for the questions. Jonathan, thank you. I always learn so much when I hear you speak. So thank you so very much for joining us. On behalf of everybody who joined today and on behalf of the HSJCC committee, we thank you so very much for taking time out of your very, very busy day, I'm sure. And I just want to remind anyone who's still on the line to please, inside the chat, there is the link for the evaluation. If you could please fill that out, we would very much appreciate that. It really helps us to plan future sessions. And Jonathan, I got to say, there's a lot of comments in the chat, and they're all, oh my goodness, thank you so very much, and miigwech.
Okay, thank you.
Yeah. Okay.
Thanks, everyone.
Thank
Miigwech.
you. Thanks
All
so
right.
much, Jonathan, and thanks to everybody for joining us today. Thank
Okay.
you.
Bye-bye.
Take care. All the best. Bye-bye now.